Welcome to the Hughes, Hubbard Anti-Corruption and Internal Investigation Practice Group's podcast, All Things Investigations. The Hughes, Hubbard Anti-Corruption and Internal Investigation Practices Group represents many of the premier companies around the world, providing advice on issues spanning the full anti-corruption and compliance spectrum. In this podcast, host Tom Fox and members of the Hughes, Hubbard Anti-Corruption and Internal Practice Group will highlight some of the key legal issues involved in white-collar and other investigations, both domestically and internationally. We will tackle topical issues involved in investigations, as well as explore how companies can prevent and detect issues that arise in conducting investigations on a worldwide basis. Today, Hughes, Hubbard & Reed special counsel Thomas Lee talked to us about the court case of NSBA versus Yellen, which declared unconstitutional the Corporate Transparency Act. Lee was part of the winning team. Hello, everyone. This is Tom Fox back for another episode of Hughes, Hubbard & Reed's All Things Investigation. Today, I'm absolutely thrilled to have with me Thomas Lee. Thomas, first of all, welcome, and thank you so much for taking the time to visit with me today.
Thank you, Tom. It's a pleasure to be here.
Thomas, you had a very big win that literally I think every compliance professional, certainly and most lawyers in the United States, are aware of, involving the Corporate Transparency Act, and I wanted to visit with you about that case. Could we start off maybe by telling you how this case you came to handle this case and who your client was?
My client was the National Small Business Administration, and one of its members, the owner of one of its members, Isaac Winkles, who lives in Huntsville, Alabama. And the NSBA has a number of members, including board officers in Huntsville. And so I came to the case because I'm a constitutional lawyer. I'm an appellate specialist, and the Corporate Transparency Act, which was enacted in 2021, is really an unprecedented federal statute. If you set up an entity, an S corporation, a limited liability company anywhere in the country, in any of the states and any of the Indian tribal nations, you have to turn over to the federal government, specifically the Financial Crimes Enforcement Network of the Treasury Department, data regarding your beneficial owners. You would think that's pretty easy to figure out, but the devil's in the details, and in the regulations, the Treasury Department defines beneficial owner to include anyone who has substantial control over decisions of the company or the entity. And if the reason why it's unprecedented is because the federal government has never regulated entity formation. That's something that's up to the states. And it's one of the reasons, one of the challenges that we brought was that this was beyond the federal government's power.
So you mentioned the constitutional claims. Before we get to those in detail, what kind of burden did you feel like, or your clients feel like, that this put on small businesses literally across America?
If you've set up an entity, and our client is the National Small Business Association, then you have to report to the federal government the name, address, active identification number with the photo of your active identification number document. That could be a driver's license or a U.S. passport. You have to report that information to the federal government. Anyone who has, and the definition again is substantial control. So let's assume you're a family-owned business a couple generations back, and I have members of the NSBA that exhibit this profile. And it was started by the grandparents. And the grandparents, they're not active anymore, but anytime the business makes decisions, the business could be a local landscaper, for example, they have to be consulted. And then really it's these questions of, okay, there are a lot of people that have substantial control in my business. Do I have to report all of their information? Do I have to get their active identification numbers? And I have to give them all to the Treasury Department. Now, you would say, what's the purpose of this law? And the purposes of the law are very admirable. It's the idea that there are a lot of people using shell corporations to launder money or to fund criminal enterprises and terrorism. And that may be true, but the reality is that this dragnet is estimated to apply to 32.6 million entities, and many of them have done nothing wrong. Many of them are American businesses, and those are my clients. small businesses, and they're the people who will roger up and report to this requirement, right? The bad actors in the world, they're just going to ignore it. And so in a way, this is the worst of all possible worlds. You have a very well-intentioned statute that is going to sweep in the very people who are innocent, who haven't done anything wrong, and who feel like they have to comply with government regs, while at the same time, the bad actors are just...
I'm not a constitutional lawyer, but I have to assume that you, as one, found this case actually not only intellectually challenging, but also quite exciting to work on. Would that be fair?
That's absolutely fair, Tom. There were 3 buckets of constitutional challenges that we raised. And so it was a 3D interesting constitutional case. So the first bucket, which is what the court honed in on, was this idea that Congress doesn't have the constitutional power to enact this sort of sweeping enactment that affects state-created entities. And that was the first bucket of arguments. We argued that it exceeded the Commerce Clause power and the taxing power and some sort of unenumerated foreign and national security powers. That's the first bucket, that this was beyond Congress's power under the Constitution. Second bucket, which the court didn't get to, were individual rights arguments. We said, for example, that it was a violation of the Fourth Amendment. It was an infringement on what people would believe would be the reasonable expectation of privacy to ask for all this data when the federal government doesn't have any specific suspicion that these people have done anything wrong, these people being our clients, and to use big data in this way to create a database that law enforcement can access down the road if they feel like they have the need to. So those were the individual rights arguments. We also made a First Amendment argument there, saying that you're compelling these entity owners to speak to the federal government, the speech being the turning over of this personal information that they would rather not. And then the third basket of arguments, constitutional arguments, were characterized as what's called vagueness. The idea is, listen, even if Congress had the power, and even if it wasn't a Fourth Amendment or a First Amendment or other individual right violation, you have a statute that can potentially impose criminal liability on Americans, and you are extremely unclear about what the person needs to do to comply with the statute. The idea of reporting anyone who has substantial control over an entity or substantial influence in its decisions, that could be an accountant, that could be, as I had indicated earlier in the podcast, that could be a prior generation of family that was involved in the company that still gets consulted. It could be outside consultants. It could be all kinds of people. And so the argument is, look, if you're going to impose on Americans this kind of regulation that has consequences, you can go to jail for a willful violation of the statute, then you've got to be clearer in what exactly you're requiring. And that's the third set of problems. So we made all 3 sets of arguments. The court only got to the first set about Congress's power, but we believe in all of them.
Could you detail your understanding of the court's reasoning around the first set of arguments around the Commerce Clause, or those that might be associated with that as well?
Absolutely. In order for Congress to enact any law, our Constitution and the Supreme Court interpreting our Constitution have said you have to have a power that is enumerated in the Constitution that allows you to do this, Congress. And those powers are generally listed in Article 1 of the Constitution. And the government had argued, their principal argument, which I'll focus on here, is that this statute is justified under Congress's power to regulate commerce with foreign states and among the United States, right? So the interstate and the foreign commerce power. So Congress has this power. And so what we had argued, and the government conceded this, is entity formation itself is not regulation of commerce. There are a lot of reasons why people set up entities. In fact, in the original period of the founding of the Republic, many entities were public entities to build toll roads or to form a village government or a township. And so the government had conceded that the regulation of the entity, formation of the entity itself, is not necessarily regulation of commerce, but the government had argued most of these entities will eventually engage in interstate commerce or foreign commerce, and they will use the channels of interstate commerce. And the court rightly rejected those arguments because the statute isn't phrased in terms of entities that use interstate commerce or affect interstate commerce. And it isn't, you can't, and this is something that the Supreme Court clarified in the Obamacare decision and for NFIB versus Sibelius, you can't regulate based on future prospective predicted activity. And so the court had said, look, you have very good reasons for doing this, but you're regulating entities, you're regulating something that isn't necessarily using interstate commerce. Those words aren't in the statute. And you're not regulating something at the time it's using interstate commerce. You're saying every entity that's formed, possibly formed, has to report this data. And so that is overreach on the part of Congress.
What about the treaty obligation requirement? How did you handle that?
Yeah, part of what's motivating the Corporate Transparency Act is the sense that the international community and other jurisdictions in Europe in particular have been pushing for this type of central database about entity ownership. And our argument there is, number one, there is no treaty here, right? These are international standards based on people who are active in the space. The United States has not signed a formal treaty with 2/3 advice and consent of the Senate and the president's signature saying that we're going to adhere to these standards. So number one, there's no treaty. And number two, regardless of the fact that international standards, and in another brief, we say we don't even think international standards requires the development of this type of database. But even assuming that international standards do require that, that is not relevant to the question of constitutional power. The treaty can't give, international standards can't give Congress any reason that it doesn't have under the Constitution. If it doesn't have power under the Constitution, the fact that international standards says it doesn't make any difference, right? And so that's our argument. And I think the judge correctly understood that to be the case.
And does Congress have any national security powers, or would those have to be enumerated specifically in the Constitution as well?
Yeah, so that's a very good question. Our position is that the government cited some cases that said, look, when it's a question of national security power or issues or foreign relations issues, that sometimes you don't have to point to a specific provision in the Constitution. We distinguish those cases and say those cases don't stand for such a powerful proposition, that basically we think that the federal government has greater powers in foreign relations, but we still think you have to point to something in the Constitution that's written down. But our principal argument there is maybe in some very limited area, there are foreign relations powers that don't have to be enumerated because these are questions of national security. But guess what? This is not a foreign relations statute. This is a domestic relations statute. Go back to what we discussed at the very beginning of the podcast, Tom. At its essence, this statute regulates entity formation. More than 32 million entities are predicted to be falling under its coverage. And so this statute really is about internal issues of entity formation, not about foreign relations. And you can't stipulate it has these foreign relations consequences, and therefore Congress has the power under some unenumerated sense of national security to do that. Imagine the world in which that actually was how our Constitution worked, right? So many issues have national security, foreign relations implications. And just by calling it that, you could regulate all sorts of individual behavior. And I think the court rightly recognized the danger of that. I thought Judge Burke's opinion was extremely thoughtful, and he clearly read all the briefing, read all the cases, and just did a thorough job of really thinking critically about these questions, which are really important questions. This is a Corporate Transparency Act. People think of it as an accounting statute, but there are some really important big themes and principles at issue here about our Constitution, about what we're willing to do for national security, and about the individual rights of small business owners and all Americans.
Thomas, could you describe for our listeners procedurally how the case went to the court's decision, where it is now, and how that sort of procedural background might play out in terms of a review or other by the Court of Appeals?
Sure. We filed the complaint initially in November of 2022, and the reporting requirements kick in on January 1st of 2024. And so we had been a good year in a couple months advance of the effective date of the corporation, of the reporting requirements of the Corporate Transparency Act. And so what we did was, rather than file for a preliminary injunction, we had negotiated with the Department of Justice an accelerated briefing schedule where we would, and now I'm getting a little bit technical for the general audience, where we would both file motions for summary judgment, and the government would also, they contested standing, and so they would also file in the alternative motion to dismiss. The government lawyers were professional, terrific, and they wanted to resolve this as quickly as possible. And so we agreed on an expedited briefing schedule. Briefing was closed in May of 2023 under this schedule that we had negotiated. The district judge, Judge Burke, then ordered oral arguments in November. And myself and my law school classmate and dear friend, John Nyman of the Maynard Nexon firm in Birmingham, who was our local counsel, we argued the case in November. And then the statute was supposed to come effective in January. FinCEN unilaterally gave an extra 90 days. So the first group of people who were supposed to report would be new entities. So if you formed an entity after January 1st, you were supposed to report, but that requirement isn't effective until April 1st. And so we were expecting a decision after oral argument as quickly as possible. But obviously, Tom, I've dramatically simplified the case for your listeners, but there are a lot of issues on moving here. And so the judge actually asked for additional telephonic arguments in early 2024. And I'm sorry, I'm looking at the exact date. And finally, we got the decision on, was it March 1st? Is that correct? Yeah.
Yes, Friday, March 1st.
Yes. And then he handed it down on March 1st. Now, the declaration of unconstitutionality, the injunction of the reporting requirements, only applies to the plaintiffs. So the members of NSBA, there's about 65,000 the member entities, and Mr. Winkles, who's the owner of a member entity that is a member of NSBA, it does not apply to other businesses. I wondered if the Treasury Department and FinCEN on its own would have delayed implementation of the statute further based on the fact that a federal court had struck it down as unconstitutional, but they have the enforcement discretion and they decided to enforce it against all others. So one of the things that we've been dealing with is we're being called a lot about bringing additional litigation, a lot of fan mail, people who support us and say, look, I want to copy your complaint and bring the exact same suit in my hometown because I think it's unconstitutional too, and I don't want it to apply to you. There's a number of litigation reasons why we did it the way we did. The most important general reason is we wanted to have this efficient, fast, and we wanted to get to the constitutional issues without dealing with procedural things like preliminary injunctions and nationwide relief from one district judge, right? So we litigated it in a lean way. The government last Monday notified that it would be appealing, and we are currently negotiating with the appellate lawyers at the Department of Justice an expedited schedule for briefing. Again, the Justice Department lawyers have been terrific. They are professionals, true professionals, and so we're trying to, as we did in the earlier stage, expedite and get a decision out of the 11th Circuit as soon as possible. But this thing is going to go to the Supreme Court. And so whether we win again at the next stage, if we win again, the government will definitely appeal to the Supreme Court and seek petition for certiorari, which almost certainly the Supreme Court would grant. And if we lose, we're going to do the same. And so this thing's not going to be over in the sense of having a final decision of constitutionality throughout the country until the Supreme Court decides it. And I think that realistically speaking, the Supreme Court won't decide this until 2025. And this is a presidential election year. They've got a lot of fish to fry. This is a really important case, but just the nature of the thing is it's going to take some time. It'll probably be some time before we get a final decision on it.
Thomas, unfortunately, we are near the end of our time for this episode. But before we leave, I wanted to ask you if our listeners wanted to follow up with you or learn more about your work and the decision in this case, what might be the best place for them to go?
Sure. Thomas Lee. I'm special counsel at Hughes, Hubbard & Reed in New York. You can find me on the website. I am also a constitutional law professor at Fordham Law School in New York City. I've been doing that for 21 years. I've been at Hughes Hubbard for almost 9 now. And you can look me up and email me, and I will try to get back to you as soon as possible.
Thomas, I wanted to thank you again for taking the time to visit with me. I hope we can continue this conversation as appropriate in the future.
Thank you. It's been my pleasure to appear on the podcast, Tom.
This is Tom Fox again. Thank you so much for listening to this episode of the award-winning All Things Investigations. We've linked to Thomas Lee's page on the Hughes, Hubbard & Reed website, as well as the Hughes, Hubbard & Reed website in the show notes. So if you'd like more information on Tom or to get in touch with him, please check out the show notes. Thank you again for listening to All Things Investigations, which is a production of the Compliance Podcast Network.